So in City of Arlington, the majority, and Justice Scalia wrote for the majority, he said that there's no distinction that's workable or proper between so-called jurisdictional questions on the one hand and non-jurisdictional questions on the other hand. The question is basically whether the agency has been delegated statutory authority. That overall frame, that's not helpful, you would say, at that first level to Verizon. There's a case that I think ultimately perhaps the Circuit Court or the Supreme Court could rely on that might be very helpful to Verizon. And Verizon does cite the case and discuss it in its brief in the Court of Appeals. And that's the Brown and Williamson case. That was a 2000 Supreme Court case. And ultimately, there was a phrase the Supreme Court used in the Brown and Williamson case, which I think could apply as well in this instance. The Supreme Court said Congress doesn't hide elephants in mouse holes, basically referring to the impact on the nation's economy. That's what it was talking about, of the regulation of cigarettes and what a major step that would be. Well, of course, the regulation of internet providers, and particularly when it would be difficult to limit the principle, so you're perhaps not only talking about the agency's authority over the ISPs themselves, but the application providers and the content providers. That's a major step, a major part of our economy. And I just have this sense that maybe this is another case, whether the courts will latch onto that phrase or not. Step one is the question of whether Congress has spoken directly on the issue at hand. And so the court said in Chevron, if Congress speaks directly, then it said, quote, that's the end of the matter. Well, if it's not the end of the matter because there's an ambiguity in the statute, then the question in step two is the agency's regulation reasonable? Or in Chevron itself, the courts spoke of permissibility and reasonableness sort of in the same breath. So it's, I think Verizon has a credible case that in the net neutrality proceeding, essentially there was not sufficient evidence, or I would say almost no evidence, of market failure. There had been just a few isolated complaints that had been filed, and the commission imposed this whole new regulatory scheme on heretofore unregulated internet service providers, and so I think because there may not have been market power, I would say, and I think Verizon would say that the ISPs don't have market power, and absent that, it's not reasonable to impose these regulations on us. So that's a type of analysis that's going to take place in step two. I do think, in light of the City of Arlington case, probably a lot more people are going to be going back and reading the parts of the briefs that dealt with the constitutional issue. But suppose it does now reach the constitutional question. I have argued myself for a long time. In fact, I think I wrote the first law review article arguing that that net neutrality rules, as they were ultimately adopted, violate the First Amendment. The Commission's theory, of course, is that net neutrality rules not only are consistent with the First Amendment and don't violate the free speech rights of ISPs, that in fact it's the Commission's job to empower speech, and therefore they're totally in sync with the First Amendment. I don't think that's right, because there is a line of precedent which holds that the First Amendment not only prevents the government from restricting an entity's speech or a person's speech, but also that the government can't compel you to speak. Well, from my perspective, the best result would be if the court, and I'm speaking of the last court, whether it's the Court of Appeals or the Supreme Court, basically throws out the net neutrality rules. And then my hope would be, I think that the FCC at that point would decide to stand by. Maybe, it would talk about watchful waiting. We're going to keep a close eye on the situation, all of which is, what you would expect, but not try to do anything and just say from their perspective, they could say we may put up the good fight, but we lost. What we have to fear is that the FCC, particularly the current majority of the FCC, would attempt to reclassify ISPs as common carriers. The FCC did that, let's say it loses net neutrality and it were to do the reclassification and it actually got it through. Now, I think ultimately the chances of that surviving court appeal would be pretty problematical, but let's save that conversation for another day down the road. But the practical impact, assuming that regime were in place, would be a more rigid set of strictures than we have under the net neutrality rules themselves. The best thing to do would be just for the FCC, to stand down and go focus on some other things that ought to be doing, like incentive auctions and some other things. That would be what my advice to the FCC would be to forget about, quote, net neutrality and go do some other things that are more clearly within your statutory responsibility, and which, by the way, are important.